So hello, my name is Melissa and I'm from the Lawyers Committee for Better Housing, and we are here to talk about eviction defense. And so we'll sort of start going over a little bit about what LCBH does and what I do, and then we'll kind of get into the nitty gritty of what it means to be taken to eviction court and what sort of happens there. I often refer to eviction court as the wild, wild west. I mean, what we try to do when we provide trainings is do our best to describe the process that'll happen, with the caveat that most of the time that is what happens, but there's always a possibility that things will go awry. I am the pro bono coordinator at the Lawyers Committee for Better Housing, and we have volunteers to take eviction cases from start to finish. Those opportunities are always available for a pro bono opportunity, and I actually co-counsel all of those cases with our pro bono volunteers due to the caveat that I just mentioned, which is I can explain to you what's going to happen, I can tell you in detail what should happen, and then what actually happens, nobody knows. So, who we are. So the Lawyers Committee for Better Housing was founded in Rogers Park in 1980. We focus on Chicago. There are some exceptions to our service area, but for the most part, we serve tenants who are living in Chicago. Our mission is that all people have a right to safe, decent, and affordable housing on a non-discriminatory basis. And so a lot of our focus deals with the preservation of affordable housing for our clients in the city. We try to treat the entire person, right? So a holistic service for low and moderate income renters. We do have an income cap or limitation to allow us to serve those who are most in need. We provide direct legal rep to those individuals, so we'll represent them in a court filing, either affirmative. We do some affirmative cases, but the vast majority of our cases are actually defense, most commonly eviction defense. We do engage in public policy advocacy and as well as other types of advocacy. We have a supportive services department. This sort of arose out of the fact that when people are facing eviction or they're in eviction court or are about to lose their house in another way, they need someone to help them find a house. So we actually employ a social worker to help people guide that housing search. She does more than just send Craigslist listings. She also will help people get connected with government programs that may be able to assist them, get them on waiting lists, and also actually directly negotiate with landlords in some cases. Particularly if there is an eviction filing, our social worker really helps landlords understand what that means and whether or not it means that this person is, not going to be a good renter. The other thing that Christina, our social worker, does, which I think is really important, is she uses her social work skills, which lawyers should have but oftentimes do not have, to help a client work through what is a very difficult time in their life. So they're about to lose their house. Many times individuals will have lived in the same place for a long time and now they're being asked to leave. So Christine and her cadre of interns do a lot of that kind of counseling. I understand that this is frustrating. Here's what I can do for you. Are you willing to consider another part of the city? Those kind of things. And then we also do outreach and education, both for tenants. We actually do trainings for tenants. We organize buildings, so we'll actually do building tenant union meetings, and then we'll also do trainings for other lawyers. So let's talk about eviction court. The sheer volume of what we're talking about here is overwhelming. People are evicted every day. Lots of people are evicted every day. In Cook County alone, there's something like 30,000 eviction filings. We recently did an informal survey to see where other big cities were at. Chicago is probably on this just informal ad hoc survey somewhere around the fourth of the list when you think of big cities, New York being first, just due to size, I think. 95% of tenants appear pro se without representation. I believe we're supposed to call these self-represented litigants now. So 95% of tenants are unrepresented or representing themselves. And a lot of times what happens is that that first court date that they become aware of is the only court date. They'll actually go to trial, and I put it in quotes, you guys, trial that day, and the trial will last something like 104 seconds. I don't bring my stopwatch to court, but it's really, really short. The amount of defenses that people are allowed to present is extremely limited. People are not sworn in. You often have people who appear to be just friends talking about what happened, and the judge is taking their word for it. Judges don't ask to see any proof of anything often. And, if the tenant is unrepresented, it's much easier for a landlord to get an eviction order. So a lot of these statistics are from a report that we issued in 2003, where we did a lot of court monitoring and observation and wrote that report. But I was in eviction court today, and I can tell you that this happens every day. These are routine things that happens. One of my most recent favorite cases is where the judge asked the landlord's attorney, so the landlord was represented, the tenant was not. Could I see the notice that you gave the tenant to terminate the tenancy? And we'll talk about that in a second. And the landlord's attorney was like, oh, I don't have it. It's in my briefcase in another courtroom. And so he actually turned to the tenant and said, remember that notice that I gave you? And the tenant was like, yeah. And the judge was like, okay. And then proceeded to issue an eviction order. And so I don't know if that counted as direct examination by the attorney to the defendant, but it counted for that. And, that's an eviction order is an order to get out. That's the final order in these kind of cases. So what do we do and what kind of things do we focus on? So we focus on cases with meritorious defenses. We don't just take every case. We do our best to give tenants a voice in court and to raise the meritorious defenses that they have, because a lot of times without an attorney, you'll never get a chance to present them. There are several appellate cases that dictate that the eviction process must be followed exactly. So a lot of our cases will have procedural defects in them. And we do this to make sure that people are following the law the way that they should, and also adhering to the appellate case. We focus on cases where we're going to help stabilize a family. And so oftentimes by the time someone gets to eviction court, that is, your landlord has brought you to eviction court, the relationship has deteriorated to the point where it doesn't make a lot of sense to engage in a defense if the tenant doesn't have an exit plan. So are they looking to move? And so sometimes what's best for our client is to negotiate a settlement that is favorable to them, that gives them enough time, that might waive some back rent that they owe, but to help them stabilize and move on to something better. And then we also appeal decisions. One of the things about the eviction court being the wild, wild west is that there's prime material for appealing something if something atrocious happens. But resources dictate that those are limited. And the other thing is that there are no court reporters in eviction court. So if you want to appeal something, you've got to make sure you've got some record of what actually happened. So this next chart, it has the relevant laws on it, because I guess we should talk about law today. The federal law, there's, the Fair Housing Act. We don't do a ton with the Fair Housing Act just because we often focus on other things, but that's out there, and it's always a pretty good defense if you can use it. The Forcible Entry and Detainer Act is actually the Illinois statute that governs eviction proceedings and tenancy in general in Illinois. So you'll often hear eviction cases referred to as forcibles or a forcible complaint. That's where it's coming from. And then the Forcible Entry and Detainer Act counterplays and is overlaid by the Chicago Residential Landlord and Tenant Ordinance. The RLTO, as we refer to it, has a number of strong tenant protections in it. And in fact, I hear that a lot from landlords, that tenants don't need your help. They have enough protection under the RLTO. And it's hard to explain to someone that a law is not self-executing, that someone has to enforce those rights for it to actually be protected. However, on paper, the RLTO does a lot of good things and protects tenants, but it's about enforcing them. A couple other laws listed here. There is a prohibition against retaliatory eviction, meaning if I complain to a governmental authority about the conditions in my apartment or where I live, then I shouldn't be allowed to be evicted after that. The Residential Landlord Tenant Ordinance has pretty strong protections against retaliation. The Illinois statute it's a little bit more difficult to prove what's going on. And then we've got a couple laws pertaining to foreclosure. Many times after a building is foreclosed upon and a new owner is brought in, so the bank owns it or some other owner, they're going to want those existing tenants that are living there out. And so there's a couple laws that deal with when a building is foreclosed and there's tenants living there. In particular, the Keep Chicago Renting Ordinance protects and offers a lot of protections for a tenant who's living in a foreclosed building. And in fact, LCBH, we offer a tenants in foreclosure helpline to help people navigate that process. A lot of times, people only hear that the building is in foreclosure through word of mouth. They receive no notices, and they have no idea who the owner is or who to pay rent to. And so we kind of help people navigate that. The other thing is, I mentioned that we sometimes bring affirmative cases. A lot of our affirmative cases are those violations of the Keep Chicago Renting Ordinance. And the idea is to educate banks and other people who are buying these buildings about the rights that tenants have in those buildings. So, how do you get evicted? The first thing that has to happen, and it's often overlooked, is there has to be some sort of notice provided to the tenant that the tenancy is being terminated. And it has to be properly delivered. So I can't just tell you, and I cannot tell you how many cases I have right now where the landlord has texted the tenant and said, I want you out. That's not a notice, okay? The notice has to have statutory language in it indicating that's a proper termination of a tenancy. We'll talk in a minute about when certain timelines and what notice does what. But the first thing that has to happen is a notice. Then, after I've served a notice and the notice has expired, meaning that the time to cure or the date of the notice has expired, then I can file an eviction action. There are two types of eviction action. A single action is for possession of the apartment only, meaning get out. The joint action is get out and pay me. So get out and you owe me back rent. So really get out and pay me. Oftentimes, whenever I see an action that's just based on possession, so it's a single action, it really usually means to me that this tenant is going to have to get out because the landlord has dug their heels in. I don't want your money, just leave. Those are fun cases. I have one right now. So then, after the eviction action is filed, there has to be service, just like there would be in any other lawsuit. Service by the sheriff, and there's personal substitute and court-appointed special process server or constructive service. And we'll talk a little bit more about service and how to challenge it in a second. Then we can go to court. After proper service, then you can appear in court. Just like any other trial or appearance, but everything's sort of condensed. And there's not a lot of formality to these proceedings often. If after a court appearance and trial, the tenant has lost, then the landlord can get an order for possession. Just a few things about orders for possession, because I think sometimes this is misunderstood. An order for possession is from the judge. The order for possession has to be registered with the sheriff. So a landlord, after receiving an order for possession, cannot go and self-help and change the locks at that point. The sheriff actually has to go out and enforce the eviction order or the order for possession. One of the things that people talk about and we hear a lot about is that the sheriff is delayed in enforcing orders for possession. So if I'm a landlord and I went to court and I got my order for possession and I'm pumped to get this person out, after you register with the sheriff, it's common knowledge that the sheriff is typically at least 2 weeks behind in enforcing orders for possession. So even if someone is being asked to leave and they have the order against them, they typically have another actual 2 weeks to get out of the apartment before the sheriff comes. And then there's also Tom Dart, who's the sheriff in Cook County. He has some policies where he won't evict if the temperature is below a certain degree. So you'll often hear that the sheriff won't evict in the winter. and I say no global warming, right? Because if the temperature is we happen to have a warm day in January, the sheriff will be there. The sheriff will try to evict people. So it's based on the temperature, not the time of year. And I think that that's something that landlords will gripe about and landlords attorneys will gripe about. But to me, it's less serious than they say, provided the weather is warmer. Okay, so what type of notice is appropriate in what situation? So a 5-day notice is for non-payment of rent. So any amount of rent that's unpaid, I can give you a 5-day notice, and you have to get out after that notice expires. If you do not pay the full amount of rent, then I can take you to eviction court. A 10-day is for a breach of a lease provision. More and more, I am not seeing actual written leases between landlords and tenants. And so a 10-day notice is extremely rare in those cases. 10-day notices happen a lot if the property is subsidized in some way. So if the landlord is receiving a rent payment from some other government entity, that's when you get the 10 days, because that's how they can get out, because the rent will be paid. It has to be a material breach of a lease, and we'll talk a little bit more about that in a second. A 30-day is what we refer to as no cause, or just termination of a monthly tenancy or a non-renewal of an annual lease. This is a lot of times where our retaliation cases come from. So you called the city, but you're current on rent about the conditions, and so I want you out because you've bothered me. That's a lot of our retaliation cases. And then you actually get 90 days notice for a foreclosed building, unless it's covered by the Keep Chicago rental ordinance. If it's covered by the KCRO, you get a 21-day notice and then an election to either preserve the tenancy or to pay you relocation assistance. And then if there's an eviction order, they have to give you 90 days. All right, so I talked a little bit more previously about procedural defects and the fact that the eviction statute has to be followed precisely. So what should the notice include? All of the notices have to be dated, and they have to be dated. We play a lot with the dates because a lot of people blow the timeline because the date of service does not count towards the date in the notices. So if I gave you a 5-day today, I actually cannot file my case until after the 6th day. So the 5 days starts running tomorrow. If I do, the case would be prematurely filed, and that would be prime for a motion to dismiss. I have to give a description of the premises, meaning the address has to be on there. It has to include the apartment number. And so this sometimes gets kind of fun if the landlord is sort of handing out eviction or notices sort of all at once. A lot of times you won't have the apartment number at all, or it will include a different apartment number. And that's grounds for a motion to dismiss as well. It has to have the proposed date of termination, but it doesn't actually have to have the date. It just has to say 5 days later, 10 days later, or 30 days, or 90 days later. We can sometimes get people when they put the date on the notice, because a lot of times that date will be wrong. But more and more, as we're seeing more statutory forms and common forms, it'll just say 5 days after the date of service. A 5-day notice actually include how much rent is owed, and it cannot include court costs or fees. A lot of times people will try to say, hey, include my attorney's fees in your 5-day notice. You can't actually do that. And that's actually a violation of the residential landlord-tenant ordinance. For a 10-day notice, you have to specify what lease provision was actually breached. So how did you violate your lease? And it has to be material. So this is an example of a material lease of a breach is no pets and you have 6 dogs. A material breach of a lease is not you put a slug in the washing machine. But we've seen those cases, right? The laundry room is ripe for 10-day notices is what I feel like, because there's always cameras in there, and it's always like landlords are really, really protective of those laundry machines, okay? Like they really get upset if someone messes with them. We would argue that's probably not a material breach of the lease if no property was damaged, right? So I put a slug in the washing machine. Okay, I got my laundry free, but is the washing machine still working? let's move on with our lives, right? So, but a lot of times people won't be able to negotiate that with their landlord without the help of an attorney. You have to be given, and then for a 30-day notice, there's actually no violation required, but it can't be retaliatory, just to remember that. One of the things that people often get tripped up on as well is the fact that a 5-day notice has to give you time to pay the rent, but a lot of the 5-day notices that we see will indicate that the rent must be paid in full. So you have to pay the full amount alleged to be owed. This is tricky in the time that people try to pay, because a lot of times people will try to pay what they think they owe, and the landlord will be asking them for more. So these are interesting cases in that way. A 10-day notice has to offer a cure period, so you have to give me an opportunity to fix the breach. A lot of times we run into difficulty with these cases because if you're alleging a past criminal or bad act, I cannot go back in time, as far as I know, to fix or prevent the bad act. So the 10 days to cure is a little tricky. In the case of a pet, it actually can be done, right? I promised to get rid of my pet snake, is a fun case that we're dealing with right now. In a 30 or a 90-day, they don't have to give you any cure period because they're not acting like you did anything wrong. They just want you gone. So I mentioned pretty significantly already that a lot of times we will be filing a motion to dismiss. For the record, you know, we all love Illinois civil procedure, and that there are two different types of motions to dismiss, one based on an insufficient complaint and one based on basically no jurisdiction or failure to plead an actual breach. The insufficient complaint is extremely rare in eviction cases because the statutory forms for complaints are very simple. Here's the address. Here's what you did wrong. I want you out. It's basically 3 counts, and it's pretty rare that things are wrong. The other thing is if we bring a motion to dismiss, a lot of times the judge will say, well, can't you just fix that problem? So if you put the wrong unit number, the judge will often give the plaintiff leave to amend to put the right unit number. So it may not solve your problem there. No notice is for the lack of subject matter jurisdiction, which is really the lack of, failure to plead an actual breach of anything. No notice. So like I said, landlord texts you and then says get out, and then so many days later they file an eviction action. Something's wrong with the notice. It's not dated. It doesn't have the apartment number on there, etc. Defective service of a notice. So there's bad case law out there that basically says if you did receive the notice, then it's okay. So we get a lot of these in a 5-day. So I received a 5-day notice by sliding it under my door, which is not appropriate, or I handed it to someone who's not appropriate to receive the notice. But I actually got it, and then the case wasn't filed until 10 days later. So the judge will often say, and that's what this case says, is, well, you actually did have time to cure the breach, to pay if you wanted to, and it's already been more than 5 days, so you're holding on to it, who cares? So this can be challenging. Defective service is the point. Premature filing. So again, a lot of people blow that because they will not count the date of service in their counting of the days. And I see prematurely filing cases not just from self-represented litigants, but big law firms who do this all the time will sometimes prematurely file cases because they just count wrong. And so we're better at counting. If the notice actually doesn't give the required number of days either. So it's not just prematurely filed, but you've misstated the notice. And then there's all these fun things about waiver. So if you accept rent after you've given someone an eviction notice, that's waiver of your alleged intent to evict them. And so that can be dismissed, provided that you actually accept the rent. A lot of times landlords will give multiple notices. So I gave you a 5-day, but then I gave you a 30-day, and then I filed the case 10 days later. That would be, at least grounds for a motion to dismiss because there's so much confusion. How is the tenant supposed to know what to do? And then every once in a while, we get someone who signs a new lease after they've been given an eviction order. You can't proceed on the bad notice after you've signed a new lease. So there's opportunities for motion practice in eviction court. It's fun. All right. Filing an action. Again, you can only bring an action after you've served a proper notice and you've given the right amount of time. A single action for possession or a joint action for possession of the apartment plus some rent. In eviction court, cases are randomly assigned into what we refer to as non-jury or first-time up courtrooms. There are a lot of people in all of these courtrooms every single day. What we do is we file jury demands because these courtrooms, not just because we want to slow things down, and we'll talk about that in a second, but because you have to wait a long time for your case to be called in these courtrooms. So even if I'm representing myself, would I want to wait an hour every time I have to go to court, or would I rather be done in 10 minutes like most people are able to be? So filing a jury demand, they must be filed prior to the first appearance unless there's counsel. And so if we get a case where a person has requested a week to talk to an attorney, which I should mention, self-represented tenants are supposed to be given a week's continuance to consult with an attorney automatically. And you'll see, I hesitate to say that because nothing is automatic in eviction court. I've now instructed tenants, say you want an attorney, say nothing else. Do not talk to anyone. Just say you want an attorney and wait for the order that says you're getting a week's continuance to get an attorney. It's sort of like being arrested, right? I want to speak to an attorney. I want to speak to an attorney. I want to speak to an attorney. Unfortunately, if people waver a little bit, they'll often end up entering into agreements with the landlord or the landlord's attorney that may not end up protecting their rights the way that sometimes we feel they should. And so that's why I'm sort of cautioning people. The other times, we have had situations, and we've had situations recently where the judge is just denying that continuance. And it's unclear why, considering it's supposed to be practice. Things are getting a little bit better with some turnover of judges, though. When I've seen the issues, it's because the tenant has wavered or not said the exact right words. I want a continuance, but they didn't say they wanted a continuance to speak to an attorney, and sometimes that'll get denied. So I want a continuance to speak to an attorney. All right, so service of process, everybody's favorite fun civil procedure. You can be served personally, so I gave you a copy of the service. This has to be done by the sheriff typically, unless you've got a court-appointed special process server. You can be served by substitute service, but the person has to live there or be a family member, and they have to be over 13. So if my 12-year-old answers the door, it doesn't matter that my 12-year-old lives there. They have to be served by someone else. A family member is typically not a boyfriend unless the boyfriend lives there. So that's an interesting one. But if mom babysits the kids during the day, so my mom babysits my kids at my house, and she gets served with an eviction summons, that's probably okay. There's case law indicating that that's probably okay. You also have to follow up by mail by providing the actual summons that way. Constructive service is kind of fun. So it can be done by publication. So you can actually publicize in the Chicago Daily Law Bulletin because so many tenants read that. Or by posting, that is, actually putting it on the door. A lot of times we see these in foreclosure cases or because they were too lazy to appoint a special process server. So the sheriff went out once, and then I'm like, yeah, I'm going to post it. Right? Well, that's not enough. You have to file an affidavit saying you can't find the person or they're intentionally evading service. Those are fun cases. If there's constructive service and the tenant does not show up to court, the landlord cannot get any money judgment. You can only get a possession order, but no money judgment. So sometimes if someone intends to vacate the apartment and they've only been served by posting, the question of whether they should actually show up to court is an interesting one. We never advise people to do anything that would be improper. So when can you sort of quash service? So personal service made on the wrong party, meaning you didn't name me, but I'm personally served. Well, if I'm not a named defendant, then you did not achieve personal service. Substitute service, I mentioned a second ago. Service by posting without sufficient attempts at personal service. So it's usually twice by the sheriff, then a special process server that's appointed by the court, then you can go to posting. A lot of people will skip those steps. The other thing that's fun is when people don't actually file those things with the court. So my special process server went out, but I didn't file the affidavit that my special process server wasn't able to complete service with the court. So if I'm a tenant or a tenant's lawyer, how am I supposed to know that you actually tried to serve me? In eviction cases, you have to be given notice of the summons 7 days before the appearance date. But having a tenant go into court and challenge that typically fails because the judge will say, but you're here now. So that's fun. More than 40 days before the appearance dates, sometimes these stale eviction cases or stale summonses. And then, there's something wrong with the affidavit. It is not uncommon for the affidavits just to completely describe someone who who wasn't a named defendant. So I am a, middle-aged white woman, and the affidavit says they served an 80-year-old black man. Well, okay, so that's probably not the right kind of thing. Courts are more liberal, and this is generally Illinois civil procedure, that if you're filing a motion to quash, you can show up once and get leave to file the motion to quash. You're not submitting to the personal jurisdiction of the court just by showing up, but you have to say something that you're not doing that. The other good thing that's happening in eviction court is that most judges, particularly if the tenant is not present, but often always, will ask to see proof of service from a landlord. So show me the proof of service. And if you show up without it, you're going to get a lot of questions. And so that's good. That's an improvement over, oh, you're here, you're evicted. So what do we do when we go to court? I mentioned that we're often filing jury demands in these cases. I'm also seeing an improvement for judges to educate tenants, even self-represented tenants, that they have a right to a jury trial, and so they could file their own jury demand. And then things kind of move forward from there. You can get discovery, and we'll talk about that in a second, but if you tip your hand that you're filing a motion to dismiss, the judge will typically set a briefing schedule on that first date, so you better be ready to have it pretty soon after. There'll be a motion hearing, and then there'll be a bench trial if you do not file a jury demand. But those bench trials are very informal, even when an attorney's involved, and they go very quickly, never more than a day. For a jury demand, you get a little bit more time, and I'll sort of talk about in a minute about how this eviction court and eviction proceedings are often a race against time for tenants. So you get another week, you get assigned to a jury room, things slow down. Jury rooms are much more civilized places. There's often less chaos, and things are much more civil on a typically, though not always. And then you actually can go to jury trial. Very rarely are we going to jury trial, but we've done it. Oftentimes what happens is that the actual defense of our client is not something the jury will understand or be sympathetic with. So sometimes you're better just pulling your jury demand and actually proceeding in front of the trial judge. So, discovery. Discovery timelines are governed by the Illinois Supreme Court Rule 213, but not in eviction court. They vary significantly depending on the judge and the case. Some judges will no problem give you 14 days to initiate discovery and 14 days to respond. Note that that's actually shorter than the Supreme Court rule, but it's eviction court. And some judges will abbreviate or extend the timeline to reflect the case. Judges hate requests to admit. They do not think they're appropriate in eviction court, and the main reason is because a lot of times your trial date will be far shorter than the 28 days someone would have to respond. Oftentimes judges are under the mistaken belief that you have to actually have leave to court to initiate discovery in eviction cases. That's the case for small claims cases. It's not the case for eviction cases, but there's at least 2 judges on the eviction floor who believe that you need leave of court to initiate discovery. So, fun. And then oftentimes you'll hear, particularly if a landlord or a landlord's attorney is objecting to your request for discovery, you'll often get questioned, intensely by the judge. Well, what do you need discovery for? What are you asking for? If I say, Judge, they're claiming non-payment of rent and I need to see a ledger, it's not uncommon for the judge to say to the landlord, the landlord's attorney, okay, how quickly can you turn over the ledger, right? So you have to be careful and understand what you need and be firm in asking for the timetable, which is sort of fun. Okay, so what are our defenses? How do we defend these cases, if at all? I mentioned retaliation a couple times. In the Illinois statute, you actually have to complain to a proper governmental entity who can control or do something about the condition of the apartment. In the Chicago Residential Landlord Tenant Ordinance, it's a little bit more lenient. You get a year, so you have to complain within a year, and it has to be something. So if I wrote my landlord what's known as a 14-day letter, meaning I have problems in my apartment, for example, there are mice here, please correct this within 14 days, or I'll take some other action. If I have proof of that 14-day letter and then the landlord tries to evict me, there's a pretty good retaliation claim there. The problem with retaliation claims, it's a rebuttable presumption, so it's not unlike discrimination. So I can come in and claim retaliation, but the landlord can say, no, that's not why I'm evicting you. I just don't like your face, right? So just like employment, particularly for a 30-day notice, I can fire you for a no reason, but not for a bad reason. But who decides what that is? Anyway, you can actually get damages if your landlord tries to evict you for improperly, retaliatorily, but those are hard to get in eviction court. The breach of the implied warranty of habitability. I've said the words conditions a number of times, meaning there's something wrong in my apartment that would violate the building code. So things like not having a door that locks, that's actually a condition, and it's also unsafe. Heat, water, electricity, rats, roaches, mice, leaking floors, leaking cabinets, low water pressure, no water, mold, lead, all of those things are conditions, and they breach the implied warranty of habitability, which means if you've offered me this place to live, you better have made sure that it's livable, right? And there's actually some really good case law, and it's accepted that, if you breach that, the apartment, and I've paid you rent, then the apartment is worth less than what you said it would, and I'm entitled to the difference. It is not uncommon for us to have these kind of severe conditions cases where the tenant has paid no rent, and I'm in that unfortunate position of having to argue that the price of the apartment or the actual fair market value of the apartment is zero. A judge recently told me everything is worth something, counsel. I'm like, okay. Utility taps are where actually you're paying for other people's utilities, either a common area or someone else's. Like, it's not uncommon in these cases for a landlord's family member to be living in the building, and you find out that you're paying electricity for landlord's mom. They're hard to prove, though. You got to have something from the utility company, and if it's water, it has to be from the city of Chicago, sort of saying, yeah, you've been paying all this stuff. Improper handling of a security deposit, so you don't provide notice of where you've deposited the security deposit. You fail to pay interest. If you are living in a place for more than a year, the landlord actually has to pay you yearly interest. That never happens. So fun. But, sometimes we can add this claim, have a defense, and then try to offset some unpaid rent. Illegal lockout or entry. So an illegal lockout can also actually include turning the utilities off. So landlords try to self-help sometimes by, I don't like you, you're not paying rent, I've called ComEd and you're not going to receive electricity anymore. That's actually an illegal lockout. So it's what we refer to as a constructive eviction, right? How can I live in my apartment anymore if you've turned off the water or the electricity or done all sorts of other stuff? One of my favorites is removing the door. This happens more all the time, where the landlord will actually come and remove your door. Like, okay, you want to live here? Now without this door, right? That's actually a lockout. It's an illegal lockout. And so the remedy, other than inside of eviction or court, is actually to call the police. And so we're hearing some funny stories about what the police do when illegal lockouts are alleged. And so we're sort of monitoring that and kind of engaging in some police department education. All right. The Residential Landlord Tenant Ordinance, a summary of that is supposed to be attached to your lease, and you're actually supposed to initial that you got it. The remedy for not receiving it is $100. But here's the other thing that can sometimes really help people. If I didn't attach the RLTO summary, then my lease is actually null and void. So this is really good if someone wants to break their lease in the middle of a lease term. If I didn't receive the RLTO, I'm out. The lease never happened. Nice to see you. So the other thing that is important to remember with all of our defenses, because we would like to throw everything we could at a landlord who's trying to evict a tenant, particularly improperly. The defenses have to be germane. What we have done and what we have seen is that everything listed above is typically considered germane. And again, these are big caveats because sometimes you get judges who say it doesn't matter if there are conditions in the apartment. This is for unpaid rent. And I'm like, implied? No, doesn't matter. Utility tap, well, it's a 30-day case, so what does it matter that the utilities were turned off or that they were paying for someone else's? So germaneness, typically we're over that hump, but there are still some judges who do not believe that you should have any counterclaims in an eviction case unless they're sort of procedural. Use and occupancy, there was a time where this was less common, and I'm sort of seeing it come back. Because Eviction Court has had so many issues with procedure and how people are treated, there was an effort to sort of expedite things and make things a little bit more civil. At that time, things were very quick. So 3 weeks from the first court date to trial maximum. Things are slowing down a little bit, particularly because there are more attorneys involved, Eviction Court is backed up, and the sheriff is less quick to come out. So I see more and more of these use and occupancy motions, and essentially it's pay rent while this court proceeding happens. There has to be a separate motion, and there has to be a court order. I did see the other day a landlord's attorney make a verbal motion or an oral motion for use and occupancy. The judge said, well, counsel, I need to see a motion, but write it and I'll grant it. So that was the hearing, and the tenant is standing there. By the way, the tenant also wanted an attorney. So UNO payments instituted while this poor person wanted the attorney. Okay. You can argue as a sort of defense to use and occupancy that, this place is so bad that there's no way I owe that much money for rent. Again, everything is worth something. And so you're going to have to prove pretty seriously about what's going on with the apartment to get it reduced. And your client has to pay the UNO. So what you're hoping then is when you get the UNO order, and a lot of times landlords' attorneys are doing this, they'll have the UNO motion prepared and just hand it to you as soon as they figure out that there's a lawyer, because they know you're going to slow things down. So sometimes settlement is the best way to go once you have a UNO motion in front of you. So let's talk about settlement. Just like any litigation, most eviction cases settle. Right? Most of them are negotiated and settled, even when there are counterclaims or other things going on. When the tenant is willing to move, you're in a whole different world, right? You can actually negotiate something. Most of the time, if the tenant is willing to move, you can get the back rent waived, whatever it is, because you're saying, look, you wanted her out, she'll be out, right? That's what they wanted, great. You can also trade your counterclaims for some sort of money. So if I know I have a really good defense, like retaliation, I might be able to actually get my client some money to move. Those are more difficult, but if someone really wants someone out, it can work. Cash for keys are typically in foreclosure deals, foreclosure cases. So I'll give you the cash, I'll give you the keys, you got to pay me to move. This says relatively easy to settle. I'm thinking about eliminating that line. Nothing's relatively easy ever. If the tenant wants to stay and all they owe is back rent and the acrimony between the parties has not gotten too high, you might be able to negotiate a pay and stay agreement for the client to be able to stay in the apartment as long as they pay. In my opinion, you have to get a new lease after that. So you also should be negotiating for them to stay pursuant to a new lease, because what you don't want is you negotiate a pay and stay and then the next day they get a 30-day notice, right? Fun. 10-day cases, you can sometimes negotiate for a bar order, meaning if my son, who doesn't live with me, who's an adult, has been causing all sorts of problems by engaging in criminal or other menacing behavior on the property, if I can say my son can't visit me anymore, maybe I'll be able to stay. I used to use that example with a boyfriend, then I realized I was making it sound like I was some sort of a draconian. Anyway. Sometimes you can trade your counterclaims for additional time in the unit rent-free. So, I've got this counterclaim against you. Let me stay 3 months. I won't pay any rent, and then I'll start paying after that. These are more common in subsidized housing cases, absolutely, because it's harder to evict a subsidized tenant. And again, they have additional protections. They'll have a grievance hearing, all that stuff. And the rent's usually coming from somewhere else, so the landlord might be willing to let you stay. These may end up going to trial or all the way up to a summary judgment motion. Okay, so what's in our agreed order? A couple things that I mentioned that I just kind of want to follow up on. So a lot of times I mentioned that on the first court date, even if I instruct a client to go in and ask for a continuance, people are very eager to settle on the first court date. They think they're going to be one and done in the best way possible. So what often happens when people settle with each other is that the landlord gets an order of possession against you that just gives you a longer move-out date. So today is October 12th. I will agree to an order of possession. I will give you 30 days to move, meaning I cannot register the order for possession with the sheriff until November 12th. And that's not really good, right? Because I've still got an eviction order against me. It's going to show up on my credit. It's going to make it very difficult for me to move. It's always going to be with me. My credit rating is going to go down, and I won't be able to probably ever qualify for government subsidies, housing subsidies. So, but the problem is that people don't understand that order for possession is an eviction order, right? They think, oh, we made an agreement. Yeah, the landlord's attorney wrote it on something. I don't know. So what we do in these cases, we avoid the OP. We say, great, listen, you give her 30 days to move out. We'll come back November 13th. If my client hasn't moved out by November 13th, then you may be able to get the order of possession against them, right? So a compliance status to see if they've moved or paid or whatever instead of an order for possession. Typically in the cases that we settle, we want any rent claim that's being disposed of to be dismissed on that date. And with prejudice, not without prejudice. I don't want you coming back and asking for your money. And we also try to waive the claims as narrowly as possible. The state of lead in Chicago and the buildings that are affordable housing is pretty much at a crisis level. The presence of lead in buildings where people are living is shocking. And so but what often happens is that these are the same people who are being evicted. So I've got evidence of my lead poisoned child, and now my landlord has given me a 30-day notice. These are tricky cases, but even if I'm going to settle the eviction case to get my client out, I'm going to make sure that I have not waived any of her claims that she may have against this landlord for the lead-based whatever's going on and the lead poisoning. So we waive claims as narrowly as possible for those cases, but for all cases, because you just never know what could happen. So after we've settled or after a judgment, a defendant can file what's known as a motion to stay, which means you've gotten order of possession against me, but I need more time. You can file it downstairs. You can file an eviction a motion to stay. Most tenants can do that by themselves. They don't necessarily need representation to be able to do that. And the sheriff, once they receive notice of a motion to stay, though this is there's some disagreement as to whether this is actually the case. Most of the time, the sheriff will not go out, at least the Cook County Sheriff, if they have notice of a motion to stay, whether or not it's granted. So even filing the motion can give people additional time if they're really feeling like they need more time. Sealing the court file, a lot of times we're negotiating this in our agreed orders, is that the court file will be sealed. In eviction cases that are post-foreclosure, so the building was foreclosed upon and now I'm being evicted by the bank or the new owner, those are mandated to be sealed under Illinois law. So they should not show up on the tenant's record. The idea being that I didn't do anything wrong. I happen to live in a building that has been foreclosed. You can also get the sealing, the case file sealed in eviction cases in the judge's discretion. Most judges will seal a court file in an eviction case if the parties agree to it. So if the landlord says, sure, yeah, go ahead and seal the case file, I don't mind if it doesn't appear on your record, you're good. The standard is actually, though, that there was no basis in fact or law for the filing of the eviction action. And there are some judges who will force you to write that in a sealing order. And that makes landlords, particularly landlords' attorneys, uncomfortable. And there are some judges who won't seal it at all. So this is part of the reason that we co-counsel all of these cases that we give to pro bono attorneys, because we have this sort of informal knowledge about what a judge may or may not do. But sealing a court file is really good for a tenant, particularly if they had a defense and you chose to settle the case, because you don't want it to appear on their record. It is very difficult to find a new place to live once you have an eviction. Your credit rating goes down, all the things we just talked about. But not just that, the pendency of an eviction case actually impacts your record the moment that it's filed. So what we often do is we negotiate for the sealing of the case file as soon as we've reached an agreed order. So we don't wait until a compliance status date, until the person has actually moved out. What we're negotiating for more and more is seal the case file now so it doesn't appear on their record. It makes it easier for them to move. And then if the client doesn't move, then we can talk about if the case should be unsealed. You can file a motion to vacate a judgment. This happens a lot if the tenant didn't appear in court. Eviction court moves very fast. So it's not uncommon if you show up at 9:45 that your case has already been decided and there's already an order of possession against you, even though your court date was 9:30. So 9:30, 9:45, case is over. You can file a motion to vacate a judgment. If you do so within 30 days, case law indicates that it should be very liberal to vacate a default judgment of an order for possession. I had a fun case where the clients were confused and kept going to the motion counter and filing motions to continue, and they thought that continued their case, and then they had an order of possession against them. I got it vacated within 30 days because of the fact that the case law is very liberal. But self-represented litigants, we need to help them more. You can file a motion to reconsider. Good luck with that. Or you can appeal. The order for possession actually expires after 120 days if the plaintiff gets one. So sometimes you'll see those motions for extension of time to actually enforce the order. A sheriff will not go out twice on an order for possession. So if you filed it with the sheriff and the sheriff said they couldn't evict for some reason, like you weren't specific enough in your order for possession, you didn't put that the tenants lived on the second floor, they won't go back out on the same order for possession. You actually have to go back in and get the judge to reissue it. So there's some protections for tenants. All right. What is winning besides everything? What we do is we help tenants. We help low to moderate income tenants. We try to stabilize their housing, and we're trying to preserve affordable housing. That means that if someone comes to me, even if they have no legal defense that I could possibly come up with, I might take the case, right? Just to get them more time to move, stabilize, pack their belongings, talk to their family, maybe get the kids another month in school, because it's important, right? And so we limit our ability. We always have some defense. There's always something to argue, right? We're lawyers. But if someone really doesn't have anywhere to go, sometimes we'll take the case just to try to get them a better outcome than they would have gotten for themselves. So instead of an order for possession, we'll get you an agreed order and a compliance status. That's huge for someone, not having the order of possession on their record. Time avoiding or sealing the order is another one, avoiding the money judgment. And then again, not just the social workers at our LCBH provide support to clients, the lawyers do as well, and particularly pro bono attorneys. What we often do in landlord-tenant cases is we insert ourselves between the landlord and the tenant, and particularly when there's acrimony between the two, just having someone else on your side is really big for a client. And really rewarding, and dealing with someone who they have had a lot of trouble dealing with. It is not uncommon for our tenants to say that the landlord is harassing them and they have proof of it. It's not uncommon for our tenants to say that they feel threatened by the landlord. Not uncommon for us to hear stories about how the landlord is trying to enter the apartment without permission on a regular basis. And so inserting yourself in that relationship and making it making sure that your client's rights are protected in that way is a big part of what we do. So we have opportunities for start to finish eviction defense cases. We do case acceptance every Thursday. I can get anybody a case on Friday, right? And we can have a clear conflicts the next day. Those are one of our main opportunities for eviction defense. Other things that we have opportunities for, we have appeal cases that you can take. We have affirmative cases with regard to the Keep Chicago Renting Ordinance or other breaches of the RLTO that we would love pro bono help on. We do some post-possession things as well. So that's pretty much it.